She got it. She just don't want to pay for it. She trying to get her son a Christmas that I don't care about.
Always.
Right. So since she got money for Christmas, she can get my money for mine.
Can we speed this up? My phone about to die.
Don't charge it. You can get your nails done for $100 every couple of weeks, but you can't send my money. So you got it.
Right out of the gate, this courtroom is already on fire. We've got accusations flying, money disputes tangled up with personal resentment, and a judge trying to rein things in before this turns into a full-blown shouting match. This isn't just about unpaid money. It's about accountability, pride, and emotions spilling over into a legal battlefield. Stick with this case, because what starts as a simple payment dispute quickly spirals into threats of garnishment, courtroom warnings, and some jaw-dropping entitlement that the judge absolutely does not let slide.
Shaquilla Anthony versus Brandy Daniels. Miss Anthony, state your name.
Shaquilla Anthony.
Miss Daniels, state your name.
Brandy Daniel.
All right. There was a motion filed. Let me see. Was it by you, Miss Anthony?
Yes, because I haven't received payment October, November, or December. Her job haven't even put in the garnishment.
All I see uploaded is the one filed on August 4th.
I just did one December 2nd, I think. Yeah, December 2nd.
Maybe they put it in the file or not. Okay, I see it. They didn't scan it on didn't scan it in my system. I see it right here. All right. So what was this? A installment payment plan? What was this?
It was supposed to be garnished, but her job haven't turned in the disclosure garnishment paper, so nothing been happening since before October. I never, like I said, I haven't received a payment October, November, or December.
Okay. Miss Daniels, I thought we had an
Yes.
agreement that she would pay Miss Anthony monthly.
And then you went forward with garnishment, so I'm not supposed to make payments if you're gonna go through with garnishment. So I'm not sure why we keep having court dates.
So since that didn't go through, can she just send me my money? Because I'm really tired of coming to court too. I just want my money.
Sunrise is correct. Is it Sunrise Bloomfield?
Yep.
I think the garnishment stayed in place, Miss Anthony, because I don't think there was a installment order. We set aside the installment order plan. So that means the garnishment kicked back in. So for the garnishment to stop, that has to be set aside and installment agreement officially put on paper, which we can do. But
okay, we do that because they haven't even sent you guys the disclosure paper that you need to have to even garnish her. So can we stop that and she just send me my money?
Here's where the legal mechanics really matter. The court is breaking down the difference between a wage garnishment and an installment payment plan, and that distinction is huge. A garnishment isn't optional. Once it's active, the employer is legally obligated to withhold wages. But because the paperwork stalled, nothing moved forward. The judge is clearly frustrated, and you can hear it. This moment sets the tone. The court is willing to work with cooperation, but if payments aren't honored, enforcement comes back fast. So let me ask you, if you owed this money, would you prefer controlled monthly payments or the court stepping directly into your paycheck?
Right. We can do that. So we need another order, or we can draft up an order or whatever. Let me put the terms on the record. So the 200 was released. She owes $1,164. Is that correct?
Yes.
That's what I have in my file.
Yep, that's right.
So, give me 1 second. I think you agreed to $100 per month.
Yep, and she behind 300
per month. We started that back in what?
June or July. I'm not sure.
And we'll just we'll start it this. We'll start it next. Well, do you want to start this month or next month?
This month.
All right.
And what are we doing? What is this?
It's gonna be an installment payment plan, so we can take the garnishment off of you. You know, or I could just go investigate what's going on with the garnishment, make my calls, and when I make a call, stuff happen. Respectfully, so I don't know why that job hasn't even done what it was supposed to do when they got paperwork from this court. So we can get an installment
Because it
payment
go through
plan, or we can.
corporate. It don't go through them. It goes through corporate. And her
Well,
calling and harassing them is not gonna speed nothing
I
up
didn't
neither.
call and
So I don't care
harass
no,
what
no,
route
nobody.
it
no,
has to
So
go.
Miss
Just
Daniels,
get
Miss Daniels, back up, back up. I didn't say she was calling. I said Judge Bowie was going to call.
no, I'm telling you that she's calling.
I
All
did
right, well
call
that's
because
fine.
they should have put in the paperwork, but I didn't harass nobody. I never even said who I was calling for. I
Well, they
said,
said you rude, so we're
I
gonna
don't
get
care.
all
I
that
might
on
be
file
rude.
too.
When somebody mess up my car, yeah, I'm rude.
All right, so
So how do you want to go about this, sir?
I want you to send my $300.
so it'll be $100 per month. First payment.
Well, she already behind 300, so don't she have to send that? And then we
No,
start
don't have it. No. Try
getting.
again.
Another thing, Judge. So me and her go to the same nail tech. So you can get your nails done for $100 every couple of weeks, but you can't send my money. So you got it, or you
All
need to
right,
find it.
so here's the deal. It'll be $100 per month. That first payment will be due um on the 19th in 2 days, Miss Daniel. And it'll be 100
So
per month until it's paid in full. The last payment you make will be $164 to pay her off. I don't know what that last date looks like. Y'all got to do it. So
on the 19th, is she sending what she's behind on? Because I feel like she needs to send more than $100, Judge. I'm sorry. We've been doing this too long. I want to be done with her. She grown enough to know not to touch nobody's car, so she should be grown enough to pay for it.
she don't have it.
She got it. She just don't want to pay for it. She trying to get her son a Christmas that I don't care about.
Always.
Right. So since she got money for Christmas, she can get my money for mine.
Can we speed this up? My phone about to die.
Don't charge it.
Miss Daniels, Miss Daniels, you need to calm down because sometimes I think you forget who you're talking to. Okay? I'm trying to remain respectful and be a level head between y'all two, but don't forget who you're talking to. Okay? I've never disrespected you. I've never rushed you. I've heard you out. You're not gonna disrespect me, or I'm gonna go to that level you don't want me to go. So I'm trying to respectfully say, hey, Miss Anthony, let her give you 100, and then y'all figure out the rest. Okay? So relax, because you shouldn't have did what you done. You messed up.
Yeah, you're supposed to have a felony on your name. I was being nice and didn't give you one. You're
All
welcome.
right. So Miss Anthony, sometimes in life we got to take the bigger road, bro. Michelle Obama, First Lady of the United States, first Black woman ever to be that, said when they go low, we go high. Sometimes we just got to go high in this situation.
All right,
Get
but
your
if you
$100 on the
150, then
19.
Judge, can we at least settle for 150?
This is the emotional climax of the hearing, and the judge draws a hard line. When emotions override respect for the court, everything changes. Notice how quickly the judge reminds both parties who controls this room. This isn't reality TV, it's real legal authority with real consequences. The mention of a felony not pursued is especially telling. That's the judge signaling restraint was already exercised once. From here on out, compliance isn't a suggestion. The courtroom isn't just settling money, it's enforcing order. And honestly, do you think the judge was being patient or already at the end of their rope?
At 150.
Thank you.
Okay. This Friday. Miss Dan, you ain't got to pay the whole 300. Just 150 this Friday, $100 for the rest of the term, and then until everything is paid off. Okay.
And where's this being paid at?
My Cash App.
No,
Send to
thank
Miss
you. The
Anthony.
courts.
Well,
Judge,
that's you come to the court if you want to.
but I don't want to
Okay.
know because Judge, when
It'll
it
go
goes to
through the
court,
courts.
I get them missing. I don't want it to go
She
to the court.
blocked on everything, so she
No,
can't
one
get
second,
nothing
Miss
through
Daniel.
Cash App.
What you say, Miss Anthony?
Can she send it to me because I don't want it to go to the court?
Why not? You just come down here and get it. We cut you a
Oh, because
check.
when I tried that last time, they told me I couldn't come get it. It has to be mailed.
Yeah, we cut a check.
So I can come down and get the check.
As long as you sign off on it, I'll tell them just to hold the check for you and you sign
Okay,
off
that's
for it.
yeah.
All right, so 150 this Friday, then $100. We'll do it on the 19th of each month until paid in full. That'll be
So,
installment order.
oh, sorry. Go ahead.
What was you about to say?
So when she don't do it on the 19th, what we do? Because she's known for not making her payments on time.
And we'll just put the garnish back in and I just let
Then you
and
gonna
then there's
call and talk to him.
yeah, we're just gonna put the garnishment in and then I'm just gonna wipe my hands clean of this.
Thank you.
So we're all set. Thank you.
Bye bye.
Now, Mr. Brew, you need to speak with Ms. Hathaway Tillman to figure out how you want to work on paying this because now they're in post-judgment collections phase of this, so they could garnish wages, they could seize property, installment payment order, things of that nature. They can garnish income tax checks. So we'll put you in a breakout room with her real quick. I'm just trying to see. All right, so yes, get that over to us so we can file that so I can sign off on that. But other than that, we're all set.
Okay, thank you, Your Honor. I'll have that order
Yeah,
over to
Your
you.
Honor, do I have a minute for a word, please? I've not been ordered to speak.
Yes, you may. I mean, you didn't file an answer. So when you don't file an answer, it's a default judgment. You were properly served with this and there was no answer, but you may respond for the record.
Yes, thanks, Your Honor, for your time. I'm not going to speak long, but I do realize that the name on the documents being sent to me is not necessarily the name that I am used to. My official name is Benjamin, so I am at this moment contesting the request that has been put in by the petition. I believe that there are a couple of Michigan laws which require that names on official documents be full and proper names. The name that is being shown on this document that I have, the notice to appear, it just happened to have come to my address. But, at this point, I'm minded to say that that is not me. I don't have any ID that bears the name that is on the document. So, that is why I am here. So in short, it is not me. It's somebody else. The name that is on the document is actually not me.
What?
I can quote Michigan law, MCR 1109 and MCL 565.201, which all state that names on official documents, especially for court documents, should be proper names, and this document does not bear my proper name.
So we get that all the time. So also under those Michigan court rules, pleadings can be corrected. And so if the document or the complaint doesn't have the right name, then the party with whom filed the pleadings can ask the court for leave to amend the pleadings. So I mean, that's just that has no bearing on the substantive part of this. The fact that you contracted with UWM and breached the contract. The name on the pleading can be changed. So I'm familiar with the statutes you quoted, but I'm also familiar that those pleadings can be amended. So as to the underlying substantive claims in this case, you failed to answer.
Your Honor, I was, like everybody else, I was going through a couple issues, So my address was not stable until now, that I have a more stable address. That's when I'm getting the notices now. I believe I got one notice earlier this year, which I responded to. Even though the name on the document was wrong, I still responded to the plaintiff. So
we don't have any.
That's my response.
We don't have any response from you filed. We don't. Let me see. Ms. Hathaway Tillman, was this personally served or was this? I'm trying to see.
I was just going to check that now, but yes, it was personally served on July 12th.
Okay. So you were personally served with this. So, I mean, that's all the more reason. I think you signed it.
Your Honor, not to interrupt you, but I do not recall being personally served.
So let me ask you this. Are you at 11108 Willowway Court in Clinton, Maryland?
Your Honor, I am not.
So say a truce. Who is this at this address?
I used to live there, but since March I have not lived there.
Let's see. Give me 1 second. We're clicking through our e-file system.
And Your Honor, I'll note this isn't tacking. This is personal service. So he was, and we have signed affidavits to that effect saying that he was personally served. A signed affidavit, excuse me.
Is it by somebody named Mark Haygood? Haygood?
That's
the one I see.
Yes, that's what I have.
Okay. And they said he was served in Maryland.
Yes, I believe that is his last known address. And as he stated on the record, that was his address. Since it looks like, yeah.
All right. So yeah, I'm all set. So default judgment. I'll put you two in a breakout room. Maybe you can get some contact information, Mr. Brew from Miss Hathaway Tillman, so you can figure out how you're going to pay this. But next step is either garnishment, installment payment order, or ceding property. So we're all set.
And Your Honor, do you need us to come back once we're done in the breakout room, or? Okay, just wanted to make sure. Thank you.
We're all set. Thank you.
All right, have a good holiday.
You too. Thank you. All right, so Ms. McNeil, you filed an objection to the garnishment?
Yes.
I don't even know. You can go ahead, explain why you were objecting to the garnishment.
I thought at one point the car was sold for a less amount. I tried than what I'm currently being garnished for.
Okay. The car is sold for less than the amount of the loan that you took out, then you're responsible for that difference. So obviously, I don't know the background of this, Mr. Zinsky. Was this a auto loan? This was obviously an auto loan that she defaulted on the payments and the car got repossessed and sold again?
Yeah, this was auto loan. Client would have, if they got the car, they would have auctioned it off and applied the proceeds and then calculated out the deficiency balance and then sued her for the deficiency balance.
Right. So, yeah, you're still responsible for that. The loan amount you took out, you're still responsible for that. Minus whatever they sold the property for.
Okay. I'm fine with that. I just still don't think the amount, I don't think it was calculated correctly.
Judge, I did file, as soon as I got the objection, I filed a under miscellaneous on MI file, I filed an affidavit of accounting, judgment accounting. I don't know if you got that in front of you. I sent it to the defendant, mailed it to her on December 9th. I'm not sure if she got it, but it breaks down everything.
Let me see one. Okay. The only thing I have for case filing is the writ request. That was filed back on September 8th. Let me check some other tabs.
Yeah, it would be like, I think my clerk would file it under miscellaneous around like the 9th. My file.
Okay, I see it right here. It says filing not reviewed.
Yeah, I don't know if you can pull that up on the bench there.
Yes, I'm looking at it right now. It's loading.
Yeah, so that's what I combed through it all.
Okay.
And it's got everything in there.
Yep, I see it right here. $9,233.20. Judgments was entered on 12/12/18 for $9,514.13. Post-judgment interest accrual from 12/12/18 to 8/12/21 was $2,956.02. There was a wage garnishment cost of 68, income tax garnishment of 84. Payment since the judgment, they got it credited at 3388.95. There was a $2,062 payment on March of 27th this year. Was that the selling of the car? Was that the?
No, the car would have been sold before judgment. That was a tax. That was a tax refund.
Tax garnishment from last year.
Yeah.
So yeah, she still owed $9,200 on this. $99,233.20.
Right, and interest was
But
turned
does it
off.
show how?
I'm sorry. I just wanted her to know interest was turned off back in 2021, August of 21. So it's been a static amount since then.
So there's been no interest growing on this. So I mean, at the end of the day, the objections are invalid. And whatever's being held will be released to the plaintiff and the attorney. But that's how much you owe, Miss. Do you have any other questions, Ms. Camille? I can put you in a breakout room with them.
No, because I'm still not getting the breakdown of how, if it was sold. I get what you're saying. I know it was a voluntary repossession. I'm still due, but that payment, was it even deducted from them selling the car? That's what I'm still trying to figure out.
Yeah, I mean, if
So
she wants to go in a breakout room, Judge, I can probably help her with that.
Yeah, she wants to know how much was the car sold for.
Yeah.
And then is it, if we set up an arrangement, is it a way that I could not get my income tax garnished?
Go in a breakout room. That's something between you and the plaintiff to discuss.
Okay.
Right. Mm-hmm.
Will that you'll be putting that order up on my file, Judge?
Yes, put that on my.
All right.
Yep.
Thank you. Have a good rest of your afternoon.
You too. Thank you.
This is a termination of tenancy due to criminal activity on the premises, failure to main utilities, but there's a horrible feedback, isn't there? Can you hear me though? Are you
We can
able
hear
to?
you. Yes.
Okay. It centers around a notice that was issued back in the summer, where weapons, knife and gun were brandished, and obviously police activity. It was the tenant and a occupant or another person with this tenant. Altercation with other residents on this occasion, and it resulted in pulling out a gun and a knife. So that's obviously a breach of the lease. This is subsidized housing. And when I met with the named defendant, she denied the allegations when I met with her at the first pretrial.
I think with okay, that's unlawful drug activity. I was wondering, did a police report need to be attached to the complaint? But that's only for the unlawful. So let me ask you this: are Are you looking for a trial, just for a trial date, basically?
Yes, I mean, unless, Miss Bradley has reconsidered on a move-out date, then I guess that would be the next course of action.
Criminal activity, was there charges filed or anything on that?
They didn't attach it, I'm not certain, but we'll certainly have that, if that's the case.
If it's pending in court, then I want to know what's that case. So we'll set a bench trial. Be in person, Ms. Bradley, so that means you got to come to the courthouse. It will not be on Zoom. You understand?
Yes.
Or Wednesday afternoon at 2:30, Ms. Schneider. We can do.
In the end, the court laid down a clear, enforceable resolution, a structured payment plan with immediate consequences if it's violated. The judge balanced fairness with firmness, offering flexibility while keeping garnishment firmly on the table as enforcement. Across this courtroom session, we saw a powerful reminder that ignoring court orders only narrows your options, and emotional arguments never replace legal responsibility. If you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns just like this one.
The 21st or the 26th of January.
21st is fine.
All right.
At what time did you say?
30 p.m. in person.
2:30.
So, Ms. Bradley, see you January 21st, 2:30 in court.